We are diving deep today into what's essentially the blueprint for South Africa's top courts, the Superior Courts Act 10 of 2013.
That's right.
If you want to understand how the Constitutional Court, the SCA, the High Court, how they're all structured and managed, well, this deep dive is definitely for you. It's kind of a shortcut.
Absolutely. And our goal here isn't just, to list sections. It's to really unpack why this act came about. What problems was it trying to solve?
Exactly. The context.
The context, the constitutional drivers, and the practical changes it introduced. It's foundational stuff for rationalizing a system we inherited.
And that historical context is so key, isn't it? When you look back at 2013, why did the government feel the need for such a major overhaul?
Well, the source material points directly to it. The Republic, post-1994, was dealing with a court structure that was, frankly, fragmented.
A legacy issue?
Very much so. Colonial history, apartheid segregation. It left things disjointed. The Constitution itself basically mandated a cleanup job. Item 16.6 of Schedule 6 talks about establishing a judicial system suited to the requirements of the Constitution. This act was the heavy lifting needed to make that happen.
So it wasn't just about tidying up the statutes. It was about aligning the courts with core constitutional values. Looking at the preamble of the act, what constitutional ideas really underpin this whole thing?
You see three big ones mentioned right up front. First, the absolute supremacy of the Constitution and the rule of law. Section 1 stuff.
Okay, fundamental.
Then, Section 165 of the Constitution. Judicial authority rests with the courts, and crucially, they've got to be independent, subject only to the Constitution and the law.
And if the idea is modernization and transformation, that independence and how it's managed must have been a major consideration.
Oh, definitely. And that brings us to the third pillar, the role of the Chief Justice. Section 165 makes it explicit the Chief Justice is the head of the judiciary.
Not just a figurehead.
Not at all. The Act, building on the Constitution, tasks the Chief Justice with setting and monitoring norms and standards for the judicial functions. And this is key. Of all courts.
All courts, not just the superior courts.
All courts. It really cemented the Chief Justice's position as the overall manager of the judicial system's functions.
So the Act itself, in Section 2, lays out three main objectives. Can you remind us what those are?
Sure. First, consolidate and rationalize the laws, specifically about the superior courts. Makes sense.
Yep.
Second, bring that whole structure into line with Chapter 8 of the Constitution and the transformation goals.
Right, the constitutional alignment we mentioned.
And third, provide for the administration and judicial functions of all courts, including governance issues, placing that responsibility squarely with the Chief Justice.
Okay, of those three, consolidation, transformation alignment, and this new administrative structure, which one feels like it might have been the trickiest to actually implement on the ground?
Good question. I'd probably say the administrative and governance shift. Consolidating laws is complex, sure, but that third object, giving the Chief Justice that kind of overall responsibility for judicial management, that was a profound change.
Why so profound?
Because historically, magistrates' courts were often seen, maybe treated, almost like an extension of the government's public service department.
Ah, okay.
This act, following the Constitution, really reinforces that judicial authority lies in all courts. It mandated a unified approach to judicial management, ensuring independence and standards flowed right down the chain. That's a significant institutional pivot.
That definitely puts the why into perspective. So let's shift gears to the what. What does this rationalized structure actually look like? How are the courts laid out now?
Okay, Chapter 2 spells it out. You've got the three main tiers of superior courts. At the very top, the Constitutional Court, the CC. Its seat is in Johannesburg.
And who sits there?
The Chief Justice, the Deputy Chief Justice, and 9 other judges. So 11 judges make up the full bench.
Got it. And below the CC?
You have the Supreme Court of Appeal, the SCA. That's seated in Bloemfontein. It's headed by its own president and deputy president, plus other judges.
Right. And then we arrive at the High Court of South Africa. This seems to be where a lot of the structural reorganization happened.
Exactly. The Act creates the High Court as one single entity, but it operates through 9 specified divisions. Think Gauteng Division, Western Cape Division, and so on, usually aligned with provinces.
But it wasn't just creating new names, was it? It involved converting the old courts.
Precisely. That's where the transitional provisions, like in Section 50, come in. They had to map the old structure onto the new one.
Can you give us a concrete example? That always helps make it clearer.
Sure, let's take Gauteng. Before the Act, you essentially had 2 big high courts, North Gauteng in Pretoria and South Gauteng in Johannesburg. They operated somewhat separately.
Okay.
The Act rationalized this. The Pretoria Court became the main seat of the new unified Gauteng division, and the Johannesburg Court became a local seat within that same Gauteng division.
Ah, so one division, but with a main base and a local operational center.
Exactly. It clarified lines of authority, jurisdiction, and unified the administration under one judge-president for the division. It sounds simple, but administratively, that's a big step towards rationalization.
And what about accessing justice in more remote areas? Are people stuck traveling to Pretoria or Cape Town?
No. The Act keeps a circuit court system. The judge-president of a division can establish circuit local divisions, basically mobile courts, to hear cases in outlying areas.
So they travel?
Yes, they travel and must sit at least twice a year in designated places, handling both civil and criminal matters. It ensures justice isn't just a city phenomenon.
Okay, structure clarified. Now, if the structure is unified, the leadership and management must follow suit. You mentioned the Chief Justice's expanded role. How does that authority flow downwards?
It's designed as a clear hierarchy for judicial functions, reinforcing independence. The Chief Justice sets the national norms and standards, right? The big picture.
God.
Then, within each high court division, the judge-president is explicitly responsible for coordinating the judicial functions within that division. But it goes further.
How so?
Section 8 explicitly states the judge-president also coordinates the judicial functions of all the magistrates' courts within that division's area of jurisdiction.
So the High Court Judge President oversees the running of the magistrates' courts in their region, too.
In terms of judicial functions, yes. Case management, court roles, procedural standards. It creates that vertical line of judicial oversight and management that wasn't as formalized before.
Interesting. Okay, let's talk practicalities. How accessible are these courts meant to be for the public? Do they just shut down completely for holidays?
The Act actually mandates accessibility. Section 9 says superior courts must be open to the public every business day.
Every day the banks are open, basically.
Pretty much. Now, they can have recess periods. The Chief Justice determines those after consulting. But crucially, the head of each court, like the judge-president, has to ensure enough judges are available during recess to handle urgent matters or anything needed in the interest of justice.
So justice doesn't completely grind to a halt.
Definitely not. Essential functions must continue.
And who handles the day-to-day running? The admin stuff?
Yes, Section 11 covers that. The minister appoints the staff, court manager, registrars, etc., but importantly, in consultation with the head of that specific court.
So the judiciary has input?
Yes, and the court manager acts as the senior executive officer, handling the administration under judicial direction. And financially, Section 10 says expenditure comes from money appropriated by Parliament. Accountability sits with the Secretary General of the Office of the Chief Justice, who's the accounting officer.
Okay, so a clear administrative and financial structure supporting the judicial function. Now, let's dive into probably the most interesting part for lawyers and litigants, how cases are actually decided and appealed. Chapter 4 deals with quorums, the number of judges needed. Why specify these numbers?
It really reflects the weight and complexity expected at each level. For the Constitutional Court dealing with the highest law in the land, you need at least 8 judges.
8 out of 11. Why so many?
Well, think about it. If the CC is striking down legislation or interpreting fundamental rights, you want a significant majority of the court involved. It ensures robustness, diversity of thought, and legitimacy for those really crucial decisions.
Makes sense. And the SCA.
The Supreme Court of Appeal normally sits with 5 judges for appeals. But the president of the SCA can decide a matter needs more, maybe 7 or 9 if it's particularly important or legally complex, or sometimes just 3 if it's more straightforward.
And the high court divisions.
For first instance civil matters, usually just a single judge.
Yeah.
But again, the judge-president has discretion to direct that a matter be heard by a full court of that division, which is usually 3 judges.
And across all these courts, there's a fundamental rule about impartiality in appeals, right?
Absolutely critical. Sections 12, 13, and 14 all state clearly no judge can sit on an appeal hearing for a case where they gave the original judgment or order. You can't judge your own homework, essentially.
A cornerstone of fairness. Okay, Chapter 5, Appeals. This is where the Act introduced some significant changes, particularly around getting permission to appeal. Tell us about leave to appeal.
Right, this was a major tightening up. You don't just get to appeal automatically anymore. Section 17 lays down strict criteria. Leave may only be granted if the court believes the appeal would have a reasonable prospect of success.
So more than just a possibility, it has to be a reasonable prospect.
Exactly. It's a higher bar than before. Or if it doesn't meet that test, there has to be some other compelling reason why the appeal should be heard.
Like what? What's a compelling reason?
The classic example is conflicting judgments between different high courts on the same legal point. The SCA might need to step in and resolve the confusion for legal certainty. That's compelling, even if the specific appellant's prospects aren't guaranteed.
So it acts as a filter, stopping weak appeals from clogging up the higher court.
Precisely. It forces litigants and lawyers to seriously assess the merits before trying to appeal.
And tied into that efficiency idea is the practical effect rule in Section 16. What's that about? It sounds like it stocks pointless appeals.
That's exactly the aim. Section 16(2) allows a court to dismiss an appeal if the issues are such that any decision they make will have no practical effect or result.
So if winning the appeal changes nothing in reality.
Right. If the situation has moved on or the remedy sought is now moot, the court can say, look, even if you're technically right, it achieves nothing practical, so we're not spending judicial resources on it. Unless, again, there are exceptional circumstances.
Another efficiency measure. Now, what about when leave is granted? Normally, appealing suspends the original order. Section 18 deals with this. How hard is it for the party who won downstairs to get that order enforced immediately, despite the appeal?
It's designed to be very difficult. The default is suspension. To overcome that, the winning party has to apply to the court under Section 18(3).
And what do they need to show?
They need to prove, on a balance of probabilities, two tough things, and only under exceptional circumstances. First, that they will suffer irreparable harm if the order isn't put into operation immediately, and second, that the other party, the appellant, will not suffer irreparable harm if the order is enforced.
Both conditions must be met.
Both. It's a high threshold because the system wants to protect the integrity of the appeal process. Shouldn't usually execute a judgment while its correctness is still being challenged.
Okay, that makes sense. Now, here's where the Act gets really modern, I think. Part 2 of Chapter 8 introduces new procedural tools, especially for vulnerable people. Tell us about intermediaries.
Yes, Section 37A is a fantastic development. It allows a court, in non-criminal proceedings, mind you, to appoint an intermediary for certain witnesses.
Who qualifies?
Children under 18, anyone suffering from a physical, mental, or emotional condition that hinders their ability to testify, or older persons as defined in the Older Persons Act.
And what does the intermediary do?
They basically act as a communication facilitator. They convey the questions from the court or lawyers to the witness in a way they can understand, and then convey the witness's answers back. It protects the witness from potential distress or confusion, ensuring their evidence comes across clearly, without compromising the process.
That sounds incredibly important for access to justice. And what about technology? Section 37C deals with remote evidence.
Right, another nod to modernization. This section explicitly empowers courts to order that a witness gives evidence via an audiovisual link.
Even if they're overseas?
Yes, whether they're inside or outside South Africa. The court can do this if it's satisfied it would prevent unreasonable delay, save costs, be more convenient, or perhaps crucially prevent prejudice or harm to someone, like a vulnerable witness.
Provided the tech works, obviously.
Yes. The availability of suitable facilities is a prerequisite. But it opens the door for much more efficient litigation, especially in international cases or where witnesses are frail or distant.
Very practical. Okay, let's quickly touch on a couple of specific high court rules from Chapter 6. Jurisdiction seems straightforward. Divisions cover people and causes within their geographic area. But Section 28 has an interesting rule about not attaching property. What's that preventing?
It prevents using property attachment simply to create jurisdiction where it wouldn't otherwise exist, specifically against someone resident in South Africa.
Can you give an example?
Sure. Say I live and work entirely in Cape Town. Someone in Johannesburg can't just find out I own, say, a holiday flat in Durban, and then attach that flat solely to force me into the KwaZulu-Natal High Court Division for a lawsuit that really has nothing to do with KZN.
It stops them dragging you across the country unfairly.
Exactly.
Yeah.
It prevents that kind of jurisdictional fishing against residents. If you live here, generally, you should be sued where you live or where the cause of action arose, not just anywhere you happen to own property.
Got it. And finally, Chapter 8 also streamlines the actual court process, like summonses and writs. How has technology helped there?
Section 42 confirms that process from the SCA and Concourt runs throughout the Republic, as does civil process from any high court division. Then, Section 44 allows for electronic service,
Emailing summonses.
or fax, or other electronic means approved by the rules. And critically, the document received electronically, the fax printout. The email attachment has the same legal force as if the original paper document had been served.
That must save a lot of time in sheriff's fees.
Huge potential for efficiency gains, moving away from purely paper-based systems.
So, wrapping this all up, the Superior Courts Act really was a landmark piece of legislation. It took that fragmented, inherited system, consolidated the laws, rationalized the structures, clearly defined the Chief Justice's leadership role across all courts, and brought in crucial updates for appeals and procedure, like intermediaries and remote evidence. It's the legislative engine driving that post-1994 vision for the judiciary.
Absolutely, and don't underestimate its scope. As you said, it wasn't just a minor amendment. It completely repealed the old Supreme Court Act of 1959.
The whole thing.
The whole thing, plus several other related laws from that era. It really marked a definitive break and a move towards a unified system under the new Constitution.
A truly foundational act. Okay, for our final thought today, something to leave you, the listener, pondering. The preamble to the Act itself acknowledges that this rationalization is an ongoing process and more changes are likely. We also know the minister has to consult the Chief Justice before proposing laws that affect court structures or judicial functions.
Right. That's an important safeguard.
So, given that this is an ongoing evolution, how do you think that essential balance between Parliament's power to legislate for the courts and the judiciary's need for independence and effective management under the Chief Justice, how will that balance continue to play out as technology advances and new societal needs inevitably reshape our justice system further?